Hello, fellow public servants. My name is Caroline Clanky, and I'm a senior attorney with the Florida Commission on Ethics. I want to thank you for taking 2 hours out of your day today to learn about the state ethics laws applicable to elected municipal officers, constitutional officers, and commissioners subject to the annual ethics training requirement set forth in Section 112.3142. This lecture is designed to give you a familiarity with an array of ethics topics. And thus, over the next 2 hours, we are going to go on an action-packed, informationally intensive journey together. But the final slide of this presentation contains the contact information for the Commission on Ethics. And thus, if any topic that I should cover today will give rise to any questions you may have, never hesitate to give us a call, because first and foremost, the Commission on Ethics is here to serve public servants and help them to navigate the labyrinth that is compliance with the Code of Ethics. And so we're here to help. I am going to begin the lecture portion of this analysis, and I'll be popping in and out during this presentation, but I do not want my disembodied head to get in the way of the good work that we have to do today. And so let's focus on our first subject, which is the purpose of the Code of Ethics. I think it's imperative for us to understand as a backdrop before I get into the nuanced requirements thereof. The Code of Ethics is the mere codification of society's desire to protect the overarching goals of fairness, impartiality, and transparency of the government. In addition to the actual protection of these goals, the ethics laws also exist to promote the public's confidence in your actions and their government as a whole. For this reason, the Commission on Ethics as an agency was created pursuant to Article 2, Section 8 of the Florida Constitution. Our commission is comprised of 9 members that are politically balanced and are tasked with administering and interpreting the Code of Ethics for public officers and employees, which during this lecture, I'm going to refer to as the Code of Ethics. It is set forth in Article 2, Section 8 of the Florida Constitution and in Part 3 of Chapter 112 of the Florida Statutes. The Code of Ethics applies to thousands of public servants in Florida. Why? Because some portion of the Code of Ethics applies to all public officers, all public employees, including those on the political subdivision level, local government attorneys, candidates for public office, and miscellaneous others. Please note that public officers are expansively defined in Section 112.313, subsection 1 of the Florida Statutes, which defines public officers to include any person elected or appointed to hold public office in any agency, including any person serving on an advisory body. Notice that this is not contingent upon compensation either. Even those who serve without compensation on, say, for example, an appointed advisory board are still public officers and must act in accordance with the public trust. The Commission on Ethics as an agency has a multifaceted process that includes the rendering of advice, the investigation and enforcement of ethics laws through ethics complaints, the receipt of financial disclosure annually, which we will discuss a little later, and the adjudication of appeals associated with fines for failure to timely file financial disclosure. First and foremost, though, think of the Commission on Ethics as a resource for public officers and public employees. This is perhaps, it's truly the most rewarding portion of my job, but it is one in which we are here to assist with regard to guidance provided through many different mediums because we realize that the code of ethics and compliance with it is often a tricky thing, and we are here to help. For this reason, we give advice through many different mediums. The first of which is formal advisory opinions. In Florida, by law, any public officer, candidate for public office, or public employee who is in doubt about the applicability of the code of ethics to themselves, or any individual having the power to hire or terminate such a public officer or public employee, may seek a formal advisory opinion on behalf of themselves or that public employee. Formal advisory opinions are generally necessary to analyze and scrutinize novel questions of law or fact. A draft written analysis, once we receive all of the facts that are being proffered by the requester, are submitted to the Commission on Ethics, sitting as a collegial body at their meetings, and they are subject to vote and approval thereby. Once approved, formal advisory opinions are legally binding on the requester of the analysis. But for fact-intensive reasons, they are also very helpful in that they are published on our website, the Florida Commission on Ethics' website, and we have almost 3,000 published advisory opinions at this point. So it can often be very helpful, although it's legally binding on the requester, it can be helpful because those same facts often come up again and again. We refer to these as CEOs because advisory opinions, once published, will have the letters CEO, Commission, Ethics, Opinion, and then the number of the opinion and the year in which it was rendered. And so these can be very, very helpful. I'm going to be referring to some of these with the moniker CEO and then followed by a series of numbers for illustrative purposes, because there are certain seminal analyses that I think will be very helpful in case you have questions about how to deal with certain facts. We also, when there is a pre-existing surfeit of published advisory opinions, we also provide informal written analysis that is predicated upon those pre-existing advisory opinions. These can be requested via email made to our executive director. When there is a sufficiently large body of advisory opinions, we will draw upon those and apply it in accordance with those previous analyses. It generally takes, this is an expedited analysis that generally takes about 10 days to 2 weeks, and it is written. It will come in the form of a responsive written ethics analysis as a PDF directly to the requester, and generally takes about 10 days to provide. If we have all the questions and factual bases that we need to render an analysis. We also give every single weekday over the phone advice, and we return calls within the hour in which they are received every single day. There is always an attorney on call working Monday through Friday, every day of the week. And so that is something that I think is often utilized by city attorneys, county attorneys, school board attorneys, and the like. But any individual public officer or public servant can call when they are asking about facts involving themselves. It's a very excellent resource, especially for time-sensitive queries. Complaints. The Commission on Ethics also receives and investigates complaints in Florida. And complaints are filed under oath, meaning they have to be in writing and under the person's sworn notarized signature. Complaints must allege, in order to be investigated, sufficient facts or allegations indicating that some portion of the code of ethics has been violated by an individual public officer or public employee. About 225 complaints are received by the Commission on Ethics a year. However, in election years, for example, such as 2020, that can be exceeded, which it has. Approximately 60% of the complaints that we receive sufficiently allege facts implicative of the Code of Ethics, such that they are subject to an investigation by our full-time set of investigators. At a certain phase from the time that a complaint is submitted to the Commission on Ethics to a time in which it is either dismissed for being legally insufficient, or at which time a probable cause determination is made by the full Commission on Ethics sitting as a collegial body. The matter is confidential during that period, and the respondent is the holder of that confidentiality. But the good news here is that the Commission cannot self-initiate a complaint against an individual public officer or employee. Thus, there is no downside to ever inquiring with the Commission on Ethics. We are not going to glean information and use that information against you, or record that phone call and then use that as the basis of a Commission-generated complaint. The only caveat to there, as denoted by the asterisk, is the fact that there are certain statutorily generated complaints, like audits of executive branch lobbyist compensation reports that occur annually, for example. I know what you're thinking. You're probably thinking, Caroline, out of these complaints, what percentage of public officers, such as myself, in your particular public position, are subject to this type of complaint process? And you can see from this slide that often being elected individual subjects you to perhaps more scrutiny by those around you, and therefore more ethics complaint filings. Here's a complaint breakdown, should you be wondering what type of ethics matters get investigated the most. And during this presentation, I am going to be conversing with you about each of these respective analyses. However, as you'll see, the misuse of public position, which is prohibited by section 112.313 subsection 6, is going to come up after we break in the second hour of our presentation, so that gives you a reason to stick around. I'd like to begin with financial disclosure, though, because it is something that applies annually to all of the individuals with whom I'm conversing today. And so financial disclosure is a great place to start any substantive ethics lecture. The purpose of financial disclosure is to remind public officers of their requirement of putting their public responsibilities before that of their personal financial interests. The annual financial disclosure filing that you provide is also perhaps one of the only documents that is publicly accessible by any member of the public through a public records request that would enable them to discern if a particular public officer has a conflict of interest as well. So it is absolutely imperative in order to effectuate the transparency that's necessary for good governance. There are two types of financial disclosure in Florida. There is the full and public financial disclosure required by section 112.3144 and effectuated via the filing of a Form 6 every year. And then there's the limited financial disclosure required by section 112.3145, applicable to an array of local and state officers as well as specified state employees who file a Form 1 annually. As you can see from this slide, though, there are more than 37,000 people who file financial disclosure every year. And so As a state, it is a massive undertaking. I want to talk to you a little bit about some of the most frequently asked questions that we have, and to remind you about certain statutory deadlines. People often ask, when do I file? So for established public officers and public employees who have to file financial disclosure, myself included, the annual filing deadline is by July 1 of every year. However, and this is why we take trainings, there is a penalty-free grace period until September 1 of any given year, okay? So say you forget about your financial disclosure requirement and it's July 22nd. Have no fear, you're well in advance of the September 1st, real hard and fast impediment deadline, and it's better to file late than not at all, always, okay? So please do not hesitate to file. And if you file before September 1st, there's no fines. People often ask about confidentiality regarding certain information, because once filed, all Form 1s and Form 6s are a public record subject to public scrutiny. I strongly recommend that prior to filling out any financial disclosure form, any filer should take 15 minutes to read the detailed instructions that accompany each form. Because oftentimes we see an unfortunate either non-compliance, perhaps indicative of not having read those instructions, or oversharing when it is not necessary. As you can imagine, there is an array of information germane to conflicts of interest analysis that can be represented on this form, especially with regard to Form 6 filers who file full public disclosure. And so the redaction of certain information is always a question that frequently comes up. There are certain exceptions to the Sunshine Law that are statutory in nature, but that apply to certain types of filers or types of public servants and can afford them with certain confidentiality regarding particular information on their forms. And so this has to be requested in writing. However, once you have requested it, that confidentiality, that exception to the Sunshine Law, which you've identified, will allow the Commission on Ethics to redact the information which is not subject to public scrutiny by law. For example, active and former sworn law enforcement personnel can have redacted their home addresses, telephone numbers, dates of birth, as well as the names of their spouses and children. And so if, say, I were a city council member who had previously been a law enforcement officer, I could request in writing the redaction of that sensitive information, and it would proactively be redacted from your form. People often ask in this modern era if they can email the form. And with regard to Form 1's limited financial disclosure, the answer is an unequivocal yes. In most instances, they can email their form. That's because their forms are not notarized. They are merely subject to a signature. The Form 6 filings, though, have to be notarized by law at the current time and must be mailed in as a result for the most part. However, beginning in 2022, the Commission on Ethics is launching an online electronic filing portal that will enable Form 6 filers to create and file their Form 6s electronically. In 2023, this will be expanded to all Form 1 filers. So as you can imagine, this will be an incredible resource that is coming soon. People often ask, how do I fix a mistake or omission? And the easy answer to that is through the filing of a Form 1X for Form 1 filers or a Form 6X for Form 6 filers. This form enables you to identify the year of the financial disclosure filing that you are attempting to correct and allows you to correct the particular area of that financial disclosure wherein a mistake or omission occurred. You don't have to refile your whole form. You just can utilize these forms for the purposes of perfecting it. And if you file it in any calendar year prior to September 1st for that year's filing, it is legally grafted onto that filing such that no mistake or omission has occurred. So for example, I'm Caroline Glanke, I file a Form 1. If in any calendar year I were to say attend a training such as this and think, oh, perhaps I have omitted something from my Form 1, if that I filed on July 2nd of that calendar year, if July 30th of that same year, I file the Form 1X, amending or correcting that disclosure, it will be incorporated by reference into that document, and no mistake or omission will have occurred. Late filers. Oh, this is always challenging every year. As you recall, July 1 of every year is the filing deadline by law for the filing of all Form 6s and Form 1s. However, there's a penalty-free grace period until September 1st of any calendar year. After September 1st, though, fines of $25 a day, accruing up to 60 days or $1,500 begin to automatically occur. So in any calendar year, for each year, these fines may be applicable and they can really add up. Fines can be appealed, however, based on unusual circumstances outside of the filer's control that prevented a timely filing. However, I forgot is not an unusual circumstance. What normally does satisfy unusual circumstances is not having received the statutorily required notice of your filing obligation, illnesses, hurricanes, unforeseen things outside of your control which precluded your timely filing. The Commission on Ethics also has, as of 2013, many avenues by which we can collect these fines, but let's try to make sure that no such fines ever occur. But the thing to be avoided at all costs is failure to file at all. And why is this? In 2013, which went into effect July 1 of 2014, the statutory provisions in section 112.3144 and 3145 of the Florida statutes were changed such to allow a particular type of investigation. And it involves failure to file financial disclosure in any calendar year. If any public official or employee fails or refuses to file financial disclosure during any calendar year and accrues after 60 days the maximum penalty, the Commission on Ethics must automatically investigate such an event to determine whether the person's failure to file was willful. And if the Commission on Ethics finds that the failure to file was willful, the Commission has but one remedy, and that is to recommend that the officer or employee be removed from their public office or public position. As you can imagine, this is an incredibly onerous penalty and thus should be avoided at all costs. Please, even if you are very late, say you're 30 days late or 40 days late, please still file your form because it is absolutely imperative, not just for transparency requirements, but in order to mitigate these things from occurring. Okay, now that we've talked about financial disclosure, let's talk about something more pleasant, like gifts, bribes, and unauthorized compensation. So I like to bifurcate this analysis between quid pro quo, or what's commonly referred to as bribes, and the statutory provisions that address those facts and prohibits them in their entirety, and gifts. which is a far more nuanced analysis, but one of equal import. So there are two provisions within the Code of Ethics that apply to all public officers and all public employees by virtue of their import. These two statutes, working in concert together, which both are contained in section 112.313 of the Florida statutes, prohibit public officers from accepting anything of value which they know or reasonably should know have been given to influence their official action, or judgment in their official capacity, or vote in their official capacity. But notice how expansive these prohibitions are. Why? Because what we're talking about here is quid pro quos or bribes. Notice that this prohibition, the first of which appears in section 112.313 subsection 2, prohibits accepting not gifts, but anything of value to the recipient, predicated upon an understanding that it is being given to influence their vote. So, as you can imagine, anything of value can be incredibly broad. Section 112.313, subsection 4, further prohibits any public official, their spouse, or their minor child from accepting anything of value when they know or under the circumstances reasonably should know that it is being given to influence their official decision-making capacity or any node of their public performance. Okay? So notice the prohibition here expands it further to include not just the public official, but things, anything of value being provided by anyone to the official, their spouse, or their child, with the understanding that their vote or official action will be influenced thereby. So it's incredibly expansive here. For example, let's conceptualize something that could potentially be a bribe, okay? Which is essentially what we're talking about here. Under these two statutory provisions, say you are a public officer and you're celebrating your birthday at the office. A vendor of your agency, for example, comes and joins that party, much to your chagrin, and approaches you during the pendency of that fete and offers your minor child, your son, for example, a job, the promise of future employment. Now, that is something of ephemeral value, but if it has value to you, it is being accepted by your minor child, and the individual who is giving it predicates or prefaces the giving of that thing of value upon your voter official action. Like, hey, my name is Vinny the vendor, and I would love to give you or your son a job in the future if you support the renewal of my contract, which is coming up before your collegial body next year. Now, that is something that should cause alarm bells to go off. It certainly would in myself, because of the quid pro quo type analysis it engenders. So now that we've talked about quid pro quos or bribes, let's put a pin in that. Those statutes we just discussed, they apply to all public officers and employees, and now we've thought about the expansive prohibitions that are contained in those. Let's put a pin in that and move on to the gifts law. The gifts law is contained in section 112.3148 of the Florida statutes, and it uniquely applies to reporting individuals, meaning any person who files financial disclosure in Florida, whether a Form 6 or a Form 1, and procurement employees. We like to refer to these individuals as RIPEs, reporting individuals and procurement employees. And they have the specific gifts laws, the restrictions within section 112.3148 of the Florida statutes applicable to them. Let me give you some context about why these types of individuals, RIPEs, have the additional gifts laws applicable to them. The provisions of Section 112.3148 are designed to ensure that public officers who have certain responsibilities and thus have to file financial disclosure, for example, or the authority to make decisions of a pecuniary nature involving the dedication of public funds must not be able to accept expensive gifts from certain classifications of individuals or entities whom are charged with persuading them regarding the commitment of those public funds. Or, as we like to say at the Commission on Ethics, people who are paid to persuade you. Before I get into the nuances of the application of the ethics laws contained in Section 112.3148, or the gift law, let's familiarize ourselves with the lexicon of gifts. So a gift is defined in Section 112.3148 and with particularity in Section 112.312(12)A of the Florida statutes, and it could include anything that you receive for which you not give equal or greater consideration within 90 days. Section 112.312(12)A goes on to include an array of things. Here are some of them reflected on this slide, which may be gifts. But please note that they are, generally speaking, gifts are valued on a per occurrence basis. Okay? There are two limited exceptions, and that is lodging, consecutive days of lodging, and tickets. Tickets are valued not on a per ticket basis, but rather the number of tickets times the face value of tickets is the value of tickets. Lodging is valued on consecutive days of lodging basis. All the other provisions, including food and beverage, things, flowers and floral arrangements, things of this ilk, are valued on a per occurrence basis. So just to put a fine point on it, if Caroline Clanky were to take you to lunch on Monday, that's one gift. If I were to then take you to dinner on Tuesday, that is a second gift, generally speaking. But the gifts are not limitless. Section 112.312, subsection 12B, provides and identifies a whole list of things that are specifically and expressly exempted from the definition of gift. I want you to be familiar with some of these. These are the most commonly utilized exceptions to the definition of gift, including salary associated with your private employment, campaign contributions, awards and recognition of your public service, and this can include tangible items that you're given, like a watch for your tenure on a particular collegial body, or some artifact that is an award, plaques, and things of that ilk. Remember when I said that certain classifications of individuals are given particular scrutiny under the gift law? These are individuals who are paid to persuade you. They are referred to as prohibited donors within the nomenclature of the Code of Ethics, but I want to highlight two of them with particularity, because when they are the gift giver, public officers and public employees need to be very careful. And they include lobbyists and vendors of your agency. So a lobbyist is defined as any person who, for compensation, is seeking or has sought in the last 12 months to influence your governmental decision-making or that of your agency, including the modification, passage, or defeat of any recommendation or matter before your board. So the penumbra of liability, though, expands out of lobbyists by virtue of those who have retained them, okay? So the definition of lobbyist also makes as a prohibited donor lobbyists as well as the principal, partner, firm, or employer of a lobbyist. These individuals are all encompassed within the concept of a prohibited donor. You should be very careful. Vendors were also added to the list of prohibited donors in the gifts law in 2013, which went into effect in July 1 of 2014. And they are defined expansively within section 112.3148 to include any business entity doing business directly with an agency, such as renting, leasing, or selling any realty goods or services thereto. Okay? Now that we have a great grasp of who our prohibited donors are, let's talk about the two things that are prohibited under the gifts law. Because oftentimes people assume that this is a wildly onerous and very challenging metric to satisfy, but the gifts law essentially makes only two things prohibited, and I want you to be aware of what they are. The first of which is contained in section 112.3148, subsection 3, and it prohibits the solicitation. Okay, so a reporting individual or procurement employee is prohibited from soliciting a gift of any value from a lobbyist, the principal, partner, firm, or employer of a lobbyist, or a vendor, or certain others like a political committee, of any gift for their personal value, for their personal benefit rather, that of the benefit of another reporting individual or procurement employee, or the immediate family of these individuals. Okay? There is a limited exception for charitable solicitations of these prohibited donors, vendors, lobbyists, principal, partner, firm, employer of lobbyists of your agency. When that charitable solicitation is made to the individual lobbyist or otherwise prohibited donor, and the value of the thing being solicited goes directly to a charity and not to the benefit of the reporting individual, another reporting individual, or their immediate family. However, there is a limit. In Advisory Opinion CEO 98-8, the limitations of this limited exception were calcified when it was determined by the Commission on Ethics that the legal defense fund established by a state legislator was not a charity, and the solicitations made to lobbyists of his agency, the legislature, were gifts for the purposes of the gifts law contained in section 112.3148, and thus soliciting them would be prohibited under subsection 3. The second thing that is prohibited is set forth in section 112.3148, subsection 4. It prohibits any reporting individual or procurement employee from accepting, directly or indirectly, a gift from a lobbyist, a vendor, or certain others, like the principal, partner, firm, or employer of a lobbyist, valued at more than $100. Okay? So that we understand, a RIPE is prohibited from accepting gifts from prohibited donors that we've just discussed having a value of more than $100. But there is a threshold of $100 there, okay? If you were to have accepted, say, a $20 lunch from a vendor of your agency, that is well below the $100 threshold. But I want you to be cognizant of the fact that there are some statutory provisions like the K-20 Education Code applicable to district school board members that have lowered this threshold for certain classifications of public officers. But this is what the state law is. A reporting individual or procurement employee is prohibited from accepting a gift having a value of more than $100 from a lobbyist or a vendor or certain others of their own agency. Merely reporting it when it is a prohibited donor, the gift giver is a prohibited donor, and the value exceeds $100 will not cure this issue. Okay, now that we've talked about what the two prohibited things are, we've got a good grasp of that. We know we're going to be very suspicious of things being offered by prohibited donors. I know what you're thinking. You're thinking, well, Caroline, what about gifts that I receive from relatives or friends? Is there a provision of the gifts law that applies to that? And can I accept them? And the good news is that the answer is yes. Reporting individuals and procurement employees can receive a gift from a relative of any amount. It may be accepted, and it does not need to be reported. Relatives, for the purposes of the gifts law, is defined in section 112.312 incredibly expansively. And it encompasses the vast array of the concept of the blended family. It makes, it encompasses within the definition of relative an array of fiancés, grandchildren, grandparents, cohabitants sharing the same legal address. All are within the definition of relative. And if they are the donor of a gift to you, it can be accepted even if its value exceeds $100, and it does not need to be reported. However, let's talk about section 112.3148, section 8A. It provides that any reporting individual or procurement employee must report gifts from non-relatives that are not prohibited donors, so not vendors or lobbyists, so they're permissible gifts, but they're not from relatives either, and thus they can be accepted, but when they have a value that exceeds $100, they must be reported, and they will be reported quarterly on a Form 9. Once it has been reported, though, the transparency that is required for these types of non-prohibited gifts has been satisfied, and you don't have an additional reporting requirement. Sometimes we have questions about what the difference between a Form 9 for permissible gifts having a value in excess of $100, not given by prohibited donors. That is the transparency document that is utilized to report those gifts. This is very different from the Form 10, wherein you have a donor that is potentially the principal, partner, firm, or employer of a lobbyist, but is governmental in nature, and that is implicative potentially of the Form 10. But let me tell you, the Form 10 is very rare, and you would never, in any calendar year, have to report twice. You're not going to report the gift on a Form 9 and then again on a Form 10. Usually, you're going to need to report your permissible gifts that you've received on a Form 9 and not the Form 10, and you only have to do it one time. Here's what the Form 9 looks like, just to put a fine point on it. And I want to give you some advisory opinions that I think are particularly helpful when applying the gifts laws we just discussed, okay? And in particular, CEO 13-3, CEO 16-1, and 19-17. Yeah. CEO 13-3, CEO 16-10, and CEO 19-17 are particularly helpful in helping you to navigate the provisions of section 112.3148 and the gifts law as a whole. But there are certain steps that I want to talk to you about that come up almost every single time. And it goes like this. you're offered something of value and you are not going to pay for it. It's something expensive. And so, or something, you know, that should give you pause. You should attack it as such. Step one, is this a bribe? Unfortunately, that is the first step in any analysis with regard to things of value. And you should ask yourself, is this being given with an intention of influencing my official decision-making capacity in any capacity, okay? And if the answer to that is yes, full stop. This could be a quid pro quo or a bribe prohibited by section 112.313, and I should not take it, okay? But if the answer to that is no, this is not being given with an intention to influence my official decision-making, then you ask step two, who is the donor? Is it a vendor or a lobbyist of my agency? Is it the principal, partner, firm, or employer of the lobbyist of my agency? And then if the answer to that is yes, you should be very, very careful, because if it has a value in excess of $100, you are prohibited from accepting it. However, if the answer is to the question, who is the donor, it's not a vendor, it is not a lobbyist, it is not the principal, partner, firm, or employer of a lobbyist, then you can likely accept the gift, and you have to go on to the valuation provisions. Valuation of a gift to determine what amount it is valued at is often a very tricky thing. And I want to encourage you, once again, should you have questions about the value of a gift, like for example, tickets that have no face value reflected on them. That is something, or VIP bands that allow special access and you're not aware of how much that would be normally, what the value of that gift is. These are things that have come up several times in the past, and we can use advisory opinions in order to help navigate those waters and attribute a value. There are also a myriad of valuation provisions contained in section 112.3148, subsection 7, that allow mechanisms or methodologies by which a whole array of things can be valued, okay? And we can help you utilize those as well. For example, did you know that in section 112.3148, subsection 7, subsection J, there is a provision that allows you to calculate the cost of an event involving more than 10 people by dividing the total cost of all items provided during the event, including the cost of all food, beverages, and entertainment, by the number of guests invited to attend, not actually that did attend, but who are invited to attend. That enables any person to discern the value of any event. And it is an excellent thing to be aware of. But these are the exact types of things that we are here to assist in helping you to apply. And so never hesitate to give the attorneys at the Commission on Ethics a call should you have any thorny situation involving a gift or a thing of value being offered to you. Please, we also encourage you to reach out to ourselves, your county attorneys, or your city attorneys proactively. Because oftentimes there's a time window in which you can either pay down the value of the gift. If it is given by a prohibited donor, for example, you have 90 days from the date of your acceptance of that gift to pay it down such that its value has less than $100. Or in the case of a Form 9 involving permissible gifts that can be accepted, they have to be reported in the calendar quarter after the calendar quarter in which they are received. So asking proactively, kind of leaning in on these things is often very helpful from a compliance perspective. Well, we have just spoken for approximately an hour. I think we've done some good work thus far. However, I'd like to afford you a brief intermission in which perhaps to use the facilities, perhaps to stretch your legs and refresh your ability to retain the remaining ethics topics, of which there are several I'm going to discuss in the second hour of this lecture. So I'm going to give you a brief break and we will resume momentarily. Welcome back, fellow public servants, to the second hour of our ethics training. As you recall from the first hour, this training is designed to refresh your knowledge regarding ethics laws contained within the Code of Ethics for public officers and employees, and which we're going to particularly focus upon those applicable to elected municipal officers, constitutional officers, and commissioners subject to the annual ethics training requirement set forth in section 112.3142. I commend you on your returning to our ethics journey together, because I can assure you that the topics that we're going to cover within the Code of Ethics in this second hour are not only germane, incredibly, to your public service, but generate often the most questions from the public that we all serve and the most complaints investigated by my agency. And so kudos. I like to begin the second hour with a conversation about conflicts of interest. Now, let me frame this conversation we're going to have in the macro. And it's because we're going to be talking about conflicts of interest provisions that apply to all public officers or employees set forth in section 112.313 of the Florida statutes first. Now, these statutory provisions apply to all public officers and employees, whether they serve on a collegial body or not. And they exist in addition to the voting conflicts law, of which many elected collegial body members, and which is set forth in section 112.3143, are very familiar with. But merely abstention from voting does not cure the conflicts of interest provisions we're going to discuss next. That's because these conflicts of interest provisions apply to all public officers and employees, regardless of whether they serve on a collegial body and regardless of whether they are adhering to the requirements of section 112.3143. Now, mind you, to be clear, you have to, if you serve on a collegial body, you must be cognizant of and comply with the voting conflicts law. That's why I'm going to discuss the voting conflicts law later on in this lecture. But what we're going to do next is talk about conflicting employment or contractual relationships and doing business with one's own agency prohibitions set forth in 112.313 of the Florida statutes. But before we dive right into that, I like to talk about the macro, about what is a conflict of interest as it's defined within the Code of Ethics. The Code of Ethics defines conflicts of interest in section 112.312, subsection 8, rather broadly to mean any situation in which regard for your private interests tends to lead to a disregard of your public duties or public interests. Now, the provisions of 112.313 are dual in nature as they apply to conflicts of interest. And I like to address the conflicting employment or contractual relationship provisions of 112.313 subsection 7A of the Florida statutes first, because it generates often many complaint analyses. It has two separately enforceable parts. I'm going to use some advisory opinions, and you recall from the first hour of this lecture that these advisory opinions, when issued, are preceded by a CEO and then the enumeration with respect to them. They're all available for free via the Commission on Ethics' website. But I'm going to be giving some illustrative factual scenarios that are contained within those advisory opinions as examples so that we can have a granular and complete understanding of each of the respective portions of these conflicts of interest provisions. So 112.313 subsection 7A has two separately enforceable parts, the first part of which prohibits all public officers and employees from having an employment or a contractual relationship with any business entity or agency that is subject to the regulation of or doing business with their own agency. So as you can imagine, the concept of what is your agency is of paramount import in applying this statutory provision to a set of facts. The term agency is defined in section 112.312 subsection 2 rather broadly, but the Commission on Ethics, in scrutinizing this particular statutory provision, has determined that a public officer or public employee's agency for the purposes of this conflicts of interest provision is the lowest departmental unit within which the officer or employee's influence might reasonably be considered to extend. So for example, in CEO 14-27, the Commission on Ethics opined that the agency of a district school board member is that of the entire school district and the district school board that they serve, as their influence extends to that geographic agency node. However, in CEO 16-12, for example, the Commission has opined that the agency of a public school teacher is that of their public school employer. Okay? So this is important to understand in applying this provision. So let's give you some facts that may be illustrative or implicative of scrutiny under this first part of section 112.313(7)(a). Say you are an elected member of a city council, and as a result of our conversation we just had, you know that your agency is the city council itself. In your private capacity, you are a partner and part owner, an equity shareholder, for example, in a law firm. Your city council is the subject of litigation, and as such, your city council is in need of retaining a law firm for the purposes of representation. Alarm bells should be going off with regard to this conflicts of interest provision if your first thought is, oh, I know exactly who we should hire. We should hire my private practice law firm to form a contract with my agency upon which I sit on the collegial body of, and I will support the formation of this contract, and there's no need to consider anybody else. Danger, danger, danger. That danger is conflicts of interest, and in particular, the first part of section 112.313 subsection 7A. But let us not forget the second part. It is separately enforceable and perhaps equally important. It further prohibits, the second part of section 112.313 subsection 7A prohibits all public officers and employees from having any employment or contractual relationship which will create a continuing or frequently recurring conflict between their private interests and the performance of their public duties, or which would impede the full and faithful discharge of their public duties. Now that seems like a fairly broad standard, but the Fourth District Court of Appeals, in a seminal case entitled Zerwick versus Commission on Ethics, articulated a metric and methodology with which this provision shall be scrutinized by the Commission on Ethics. And it requires the Commission to engage in a comparison of the public official's private interests with their public duty responsibilities to see whether the two are separate and distinct, or in which they overlap to create a situation which tempts dishonor. And so There's a recent opinion, CEO 16-09 is illustrative of the application in particular, with particularity of this second part of section 112.313 subsection 7A. And in that, the requester, a member of a collegial body that was a county human services advisory board that existed for the express purpose of deciding the public funding levels and the public funding recipient nonprofit entities of county public funds for laudable public service providers to the members of the community. Now, in this particular requester's private capacity, he was an attorney in a private practice law firm and was personally involved in 2 lawsuits that law firm was in the midst of against 2 of the nonprofit applicants seeking funding from that particular board, whereon he was making determinations about the annual budgetary allotments given potentially to those 2 applicants. And so, applying the Zurich standard, we scrutinized whether or not that private interest engagement that he had as an attorney in private practice and partner in a law firm that was in the midst of these lawsuits against these nonprofit applicant entities created a situation which was problematic. Why? Because it created a conflict of interest wherein there was a frequently recurring impediment to the full and faithful discharge of their public duties in the form of impartiality with regard to the public funding requirements of his board. Similarly, though, but in a little slightly different metric, the provisions of 112.313 subsection 3 also prohibit doing business with one's own agency and also have 2 separately enforceable parts. The provisions of 112.313 part 1 prohibit all public employees when they are acting as purchasing agents and public officers when they are acting in their official capacity from buying, renting, or selling any realty goods or services from a company in which they themselves, their spouse, or their child are an officer, partner, director, or proprietor, or in which they own a material interest. And the commission definition of material interest set forth in section 112.312 subsection 15 defines that to be more than 5% interest. So let's unpack this first part with particularity. So public officers act in their official capacity when their collegial body votes or acts itself. Whether or not they participate in it, when that collegial body is acting, they are in conjunction with that board in their official capacity. This provision applies when any of the metrics are present. And notice the ors here. So if you were a director on the board of directors of a business entity and you did not own a material interest, this first part may still be implicated because you are in one of those statutory classes. You are a director of a business entity and you are thus prohibited from acting in your official capacity to purchase realty goods or services, for example, from that business entity, whether you own a material interest or not. If, however, conversely, you own a material interest, but in a business entity, meaning more than 5% interest, but you're not an officer, partner, or director, still these provisions may be implicated because the statutory provision has an or there, not an and. And so I want you to be cognizant of that. Once again, the concept here is protection of your impartiality when you are acting in your official capacity, and the prohibition of you acting using your official capacity position to essentially put your thumb on the scale of any business entity wherein you, your spouse, or your child is an officer, partner, director, or proprietor, or where any of these individuals, you, your spouse, or your child, owns a material interest. So let's give some, I'm going to use an illustrative example from a recent opinion that I was involved in helping to facilitate the analysis of. It's CEO 20-6, and it is implicative or illustrative of both parts. And so I'm going to use the same example twice. In this example, a county commissioner is serving on a collegial county commission body. In his private capacity, he is an owner, 100% owner, and director and proprietor of a hardware store. Now, the county maintains and is creating additional accounts with this business entity, and its different respective departments have charge accounts with this entity. During the county commission meetings, which were bi-monthly, the county commission would vote to approve miscellaneous charges made by county employees and respective departments of the county to this private business entity wherein this county commissioner owned a material interest. Now, each time his collegial body acted, and he, as a public officer, was acting as his official capacity to purchase goods and services from a company in which he was a director and owned a material interest, it potentially was implicative of this provision, the first part of section 112.313 of the Florida statutes. But let's go on to the second part, because it covers the entirety of the landscape, these two parts working in conjunction with each other to prohibit doing business with, in your private capacity, your own agency. The second part prohibits any public officer or public employee in their private capacity from renting or selling any realty goods or services to their own agency or the political subdivision of their agency. So, as we discussed, for example, the concept of agency and political subdivision, once again, require some scrutiny with regard to this. So the Commission on Ethics in CEO 14-27, for example, reiterated in the case of elected district school board members that their district school board is their agency, their political subdivision is the entire school district, for example. Similarly, in 20-6, there, a elected member of a county commission, the county commission is his agency, and the political subdivision which he serves is that of the county. But notice that it is not, however, it doesn't include other counties which are not within his elected public capacity requirements. That's not his other counties are not outside of his county wherein he's a constitutional elected public officer, are not within his political subdivision. Similarly, other cities. Let's apply those same facts though in CEO 20-6. Here we have a county commissioner. He, in his private capacity, is the owner of a business entity, a hardware store, that has maintains accounts with and provides services which are approved by the county commission at its meetings routinely. There, he would be acting in his private capacity as the owner of a business entity to sell goods and services to his own agency, the county commission. And so it is implicative, those facts are implicative not only of the first part, but of the second part. This is just an illustrative. There are a whole host of examples. This is a frequently scrutinized provision of the Code of Ethics, as is the conflicting employment or contractual relationship provisions of 112.313 subsection 7A. But we cannot leave this conversation without talking about the exceptions contained within the Code of Ethics, because they are myriad. Why? Because the Code of Ethics is designed to safeguard your impartiality and your official decision-making in your public capacity, but it is not designed to be a cudgel to prevent or preclude entrepreneurial individuals from serving in a public capacity. And for that reason, a whole host of exemptions apply. For example, in the CEO that we were using as an illustrative, CEO 20-6, one of these exceptions to the conflicts of interest provisions was applicable to negate the conflict of interest. But there are many exceptions to allow for transparency and to safeguard your impartiality, but in the public trust and in accordance with the public trust, to allow for goods and services to be provided pursuant to contracts that are not problematic under a conflicts of interest analysis. So, for example, the provisions of 112.313 subsection 3 expressly contain a grandfathering provision to automatically grandfather and thus negate conflicts of interest pertaining to contracts which were entered into prior to the individual public officer's qualification for elective office, appointment to elective office, or before a public employee begins their public employment. Similarly, section 112.313 subsection 12 includes a host of exemptions, including the sole source of supply exemption, an exemption for contracts awarded pursuant to sealed competitive bidding after a full disclosure of the public officer's interest has been made. Now, I want you to be cognizant of that last clause, okay? Contracts may be exempted from conflicts of interest when they are subject to a sealed competitive bidding process, but there is a disclosure requirement that is time sensitive and must be made prior to or in conjunction with the submission of those sealed bids. So if you want to avail yourself of that, please give us a call or ask your county or city attorney or your manager to give you counsel with respect to it, because there are certain transparency metrics in some of these respective exceptions to facilitate their application. The rotating source of supply exemption is one which has been applied in several occasions, most recently in that CEO 20-6. There are a myriad of others. There's a specific exemption in 112.313 subsection 15 for public officers who elected public officers who are employees of nonprofit entities and things of this ilk. So I want you to be cognizant of the possibility of exemptions applying and to be proactive in your seeking guidance if you would like to avail yourself or you believe such an application of exemption should apply in a certain set of facts. This brings us to perhaps the most scrutinized and applied provision of the Code of Ethics, and that is the misuse of public office provisions of section 112.313 subsection 6. You remember many moons ago when we started this journey together that I had a slide on the different types of statutory provisions that are investigated. And by far, this is the vast majority of complaint investigations include this as at least one portion of it. Because the prohibition here is so broad, the provisions of Section 112.313 subsection 6 prohibit any public officer or employee from using or attempting to use their public position or resources within their public trust to secure a special benefit, privilege, or exemption for themselves or any other person connected to them in a private capacity. Now, notice here that the prohibition is not limited to that of relatives. You are prohibited, we are prohibited from using or attempting to use our public position or public resources to secure any special benefit for ourselves or any person connected with us in a private capacity. Friends, paramours, relatives, all could be potentially included. But please note that there is a mental component here. Unlike the conflicts of interest provisions of 112.313 subsection 3 and subsection 7, which we just discussed, here there is a mental component of corruption, meaning that violations of this provision must be done with a wrongful intent and for the purpose of obtaining a benefit resulting from some act or omission which is inconsistent with the proper performance of your public duties. Thus, it is not potentially implicative or potentially a violation of this section to merely have an allegation involving a waste in government or a perceived mismanagement of public resources, or simply being rude or having a bad day. These are not sufficient to implicate the prohibition here. What is sufficient is an allegation involving intentional conduct for the purpose of benefiting oneself or another. And thus, some examples of misuse of public office include elected public officers who threaten, for example, police department employees with whom they are interfacing in a speeding capacity, or wanting to reduce or mitigate or completely exempt themselves from criminal issues that they're having. In addition, a whole myriad of things could implicate this, but conduct which is generally referred to as sexual harassment, especially when you are harassing those individuals who are provided as support staff in your public capacity. Threats made by elected officials to terminate public employees over private disputes, like, I don't like my neighbor and I would like to use my public capacity position in order to gain a special private benefit of disenfranchising this individual. But remember that it has to be a benefit, privilege, or exemption. A mere allegation of a detriment is not enough in terms of this analysis. With this in mind, I want to talk to you now about a hot off the presses, brand new constitutional amendment that is becoming effective on December 31st of 2020. So let's talk about it. This newly enacted constitutional amendment is contained in Article 2, Section 8H, subsection 2 of the Florida Constitution, and it prohibits all public officers and public employees from abusing their public position to obtain a disproportionate benefit for themselves, a family member, their employer, or a business in which they are affiliated as an owner, partner, director, or own an interest. The term disproportionate benefit has been defined by the Florida Commission on Ethics via the adoption of Rule 34-18.001 of the Florida Administrative Code. It is incredibly helpful in fully metabolizing the concepts which are contained within here: abusing your public position in order to obtain a disproportionate benefit for any of these entities connected with you in a private capacity or yourself. So please be cognizant of this. We have begun interpreting it in the form of advisory opinions. However, at the end of 2020, it becomes effective and it will be enforced thereafter. A companion a companion investigation often ensues with regard to facts alleging violations of these provisions when they involve the potential misuse of public information. This statutory prohibition is contained in section 112.313, subsection 8. It applies to both current and former public officers and public employees, and it prohibits all public officers and public employees and former public officers and public employees from using public information not available to members of the general public and gained by reason of your public position for your personal gain or benefit, or for the personal gain or benefit of any other person or business entity connected with you in a private capacity. Unfortunately, we have seen the proliferation of investigations under this provision as a result of complaints implicative of these facts in the modern era, because often there are increasingly more databases created with the use of public funds containing information not otherwise available to the public, and these databases are maintained for the public good. For example, databases containing criminal information of county and city residents. These have been investigated when facts are alleged that a public officer or public employee is utilizing or accessing these publicly maintained databases for the purpose of benefiting their private business entities of their friends, or gleaning information on their, for example, ex-spouses, which is designed for their personal benefit and not in accordance with the public trust, which is how we should be accessing and utilizing this information exclusively. Contract negotiations often have a component that's implicative of this provision as well. And so both current and former public officers and employees need to be cognizant of this prohibition and use publicly gleaned information not otherwise available to general members of the public and gleaned by virtue of their public capacity position exclusively for the public good and the public trust. This brings us to the anti-nepotism provisions of 112.3135, which is frequently misunderstood. People who are just in a passing way familiar with the anti-nepotism provisions of the Code of Ethics believe that it has something to do with the supervisory relationship, and it does not. Now, obviously, the Code of Ethics permits counties, municipalities, special districts, school districts to pass more stringent restrictions, and some of those entities have codified more stringent anti-nepotism restrictions that do involve the supervisory relationship, but they exist in addition to that which is applicable to all public officers and employees and which is set forth in the Code of Ethics. And so let's talk about the two things that are required under the state anti-nepotism law. The state anti-nepotism law set forth in section 112.3135 prohibits public officials from appointing, employing, or promoting their relatives, as that term is defined within section 112.3135, and it prohibits public officials from advocating for the appointment, employment, promotion, or advancement of a relative. So notice that these are the two things that are prohibited by the state anti-nepotism law. Now, the term relative, as it is defined within this section, is much more narrowly defined in section 112.3135 than it is, for example, for the application of the gifts law that we talked about in the first hour of this presentation. For the gifts law purposes, the term relative is defined in 112.312 very expansively. For the anti-nepotism restrictions, which are twofold and reflected on this slide, the definition of relative is much more narrow. For example, the definition of relative that's contained in the anti-nepotism law includes first cousins as relatives from which public officials are prohibited from appointing, employing, promoting, or advocating for such employment or promotion of such a relative. First cousins are in there, but second, third, fourth cousins, once, twice, thrice removed, are not. And the Commission on Ethics has, by design, narrowly construed the definition of relative as it applies in the statutory provision. So, for example, in CEO 99-5, the Commission on Ethics held that one's mother's sister's husband is not one's uncle for the purposes of the anti-nepotism provisions of this statutory provision. So in that opinion, CEO 99-5, we said that the public officer was not prohibited from appointing, employing, or promoting in his capacity on a collegial body his mother's sister's husband. He was prohibited from promoting his uncle, as that term is defined within the concept of relative in the statute, but one's mother's sister's husband, for example. Similarly, in CEO 02-3, one's paramour is not one's spouse for the purposes of the definition of relative, and the daughter of one's former spouse in CEO 14-09 was determined to not be one's stepdaughter for the purposes of the definition of relative. I mention this in a granular understanding because this provision, this prohibition, applies to unpaid as well as paid provisions, and when it is implicated by these facts, it is fairly mechanical in its application. But it does not prohibit merely two relatives from being employed in a public capacity by the same agency, such as a county or a city or something of that ilk. Rather, it prohibits public officials from appointing, employing, or promoting a relative, and it prohibits one from advocating for same. That brings us to the voting conflicts law, a statutory provision of which many elected public officers are very familiar, but I want to give you some additional information to make sure that our understanding of this, how this provision works, contained in section 112.3143, applies, and some of the metrics that the Commission on Ethics has used and which have been codified in the statute. So it applies to members of collegial bodies exclusively, and it prohibits voting conflicts. Now recall from the beginning of this hour that it acts in addition to the prohibitions that we discussed with regard to conflicts of interest, and so these are, they have their own threshold and their own definition and metric, and so let's get into what exactly that looks like in the context of the voting conflicts law, section 112.3143. So the provisions of section 112.3143 prohibits voting, requires abstention for voting, and certain other actions when a measure comes before your board for vote if the measure would inure to your special private gain or loss or to the special private gain or loss of your relative, your business associate, or a principal by whom you are retained. So the statutory prohibition is the threshold requirement, and which we must apply to each measure which comes before your board, is would this measure inure to the special private gain or loss of myself, my relative, my business associate, or a principal by whom I'm retained? And the term principal by whom retained is defined within the statute itself to include your private capacity clients, employer, the parent, subsidiary, or sibling organization of one's client or employer, or a corporation for which the officer serves as a compensated director. But one must ask oneself, is this particular measure, could it inure to the special private gain or loss of myself, my relative, my business associate, or principal by whom we're retained? And the definition of special private gain or loss has been codified within section 112.3143, subsection 1D. And I want to talk about some of the metrics that are actually contained in that statute. We first must limit the special private gain or loss to those which are economic, benefit, or harm. And so the more ephemeral benefits, which we have in our minds for the purposes of the misuse of public office provisions, for example, those are not applicable here. We're looking only at economic benefits or harms. And we must consider metrics such as the size of the class affected by the vote and the degree to which all members of that class are similarly affected or not similarly affected, the unique impact, meaning the degree to which the officer, his or her relative, business associate, or principal by whom they're retained receives a greater benefit or harm when compared to other members of the class, and whether or not the vote itself is one that is purely preliminary or procedural, or wherein the potential economic benefit or harm is remote or speculative in nature. However, there is no cure provision when it comes to voting conflicts. So if you believe it could inure to the special private gain or loss, some measure before your board could result in a special economic private gain or loss to yourself, your relative, your business associate, or principal by whom you're retained, you must publicly disclose the conflict orally prior to the vote or contemporaneous therewith, abstain from voting on the measure, and file a memorandum of voting conflict within 15 days. And the Commission on Ethics is promulgated for elected municipal officers, the CE Form 8B for this purpose. The CE Form 8A, for example, applies to statewide elected and appointed officials. However, the Form 8B is what you're going to use as a memorandum of voting conflict, and you're going to file that with the individual who retains and maintains the records of your meetings, your meeting minutes. I know what you're thinking. Caroline, I'm exhausted from all this ethics. And so perhaps you are reconsidering the holding of public office. But first, we shall not lose faith, because we're here to help. That's something that should be a major takeaway from this dialogue that we've had over the last 2 hours. But if you are serious about retiring or leaving public office, please be cognizant of the post office holding restrictions that are set forth within the Code of Ethics as well on your way out the door. The post office holding restrictions applicable to elected public officers are contained in section 112.313, subsection 14 of the Florida statutes. And these apply to elected members of county, municipal, and special districts or school districts and prohibits them from representing another person or entity for compensation before the government body or agency of which they were an officer for 2 years after leaving office. So the definition of representation is broad. The moniker that's used in the title that's contained in 112.313 subsection 14 refers to lobbying, but this prohibits representing another person or entity for compensation before your former government body or agency for 2 years after you leave public office. And representation is broadly defined to include more than just lobbying. It's defined in section 112.312, subsection 22, to include an array of activities wherein you're in a representational capacity for compensation for another business entity, including the physical attendance at meetings of your former agency itself, the penning of letters and communications to former agency personnel, and a whole host of other things. So I want you to be cognizant that the term that is used here is not merely lobbying, but representing another person or entity before your former agency. But notice, once again, before your former agency is of critical import here. Because as we recall, the concept of agency, here it is what your former agency is actually defined in the subparagraphs of 112.313 subsection 14 itself. And for example, with regard to county commissioners, it can include personnel inclusive of the county manager as your former agency. But here's what it doesn't entail. It doesn't, if you were a county commissioner, it's not going to include the city commission of the same geographic area. If you were a former county commissioner, it's not going to include the city commission as your former agency. And so you'd be free to represent, even within that 2-year period, entities before that, entities before which were not inclusive within your former agency. As I mentioned previously, the provisions of the Code of Ethics allow more stringent requirements of an ethical nature to be adopted by nodes of a political subdivision. And I want you to be cognizant that in 112.313 subsection 13, it provides that counties and municipalities are authorized to adopt by ordinance, and school and special districts are authorized to adopt by resolution prohibitions applicable to former local government employees, similar to the post office holding restrictions we just talked about in section 112.313 subsection 14. In terms of prohibiting them from representing clients before their former employer agencies within 2 years of leaving their public employment. Wow, so this brings us to the end of our ethics conversation today. And as I mentioned at the beginning of this journey, the final slide contains the contact information for the agency that is the Florida Commission on Ethics. I want to thank you not only for attending this training, but I want to thank you for serving in a representational capacity in your communities. We sincerely appreciate your service. And first and foremost, the Florida Commission on Ethics is here as a resource to help ethical individuals serving in a public capacity to comply with the Code of Ethics. The last 2 hours have facilitated that goal, but we are always here to answer questions you may have via telephone, via email, or in writing that are submitted to our agency. Thank you so much for your time today. Please do not forget that if you are subject to the annual training requirements of section 112.3142, you're going to retain for your public record purposes a record that you have attended this training, you have completed it, and you are going to reflect it on your form, your annual financial disclosure, either Form 1 or Form 6 filing. in the form of a checkbox that appears directly before your signature. And I want to thank you very much for being here with us today.